Good morning, everybody, and thanks for joining us for Cherry Bekaert's 2022 Tax Credits Incentives Virtual Conference. My name is Marty Cameron, and I lead Cherry Bekaert's Tax Credits and Incentives Advisory Group. We have a great presentation today. We actually have 4 great presentations today, and we're going to be offering up to 1 hour of CPE per session. As mentioned, today's agenda is comprised of 4 sessions, all focused around helping companies take advantage of federal and state tax incentives. Each session is going to be led by tax professionals, both from within and without Cherry Bekaert, in order to share tools, tips, techniques for developing a systematic approach to identifying, qualifying for, documenting, and calculating tax credits and incentives. We do hope you're able to join for all sessions. And in case you didn't know, you need to sign up for each session separately. So if you didn't do that, please, you'll have time to do that later today. So here's some notes before we get started. To receive CPE credit, you have to answer at least 3 polling questions and attend for the full 50 minutes. CPE certificates are going to be issued via email within 10 days. And if you haven't received yours after 10 days, please email cbhlearning@cbh.com. A recorded version of this webinar is going to be available in about a week, and it will be sent via email and posted to our website. If you have any questions during the webinar, please type them into the Q&A window in your control panel. And just note, a short survey will also be posted at the conclusion of the webinar. We value your feedback and we ask that you take part. So today, I'll give a short introduction here. I'll be speaking a little bit at the beginning just about Cherry Bekaert and our practice. And then we're going to be, I think we're really honored today to have both an outside practitioner outside of Cherry Bekaert and also representatives from the IRS. We have Paul Curtis from the IRS, Director, Small Business Division, Southwest. Cheryl Tiefer, Director, Field Operations Engineering, Eastern Compliance Practice Area at LBNI, and Alex Sadler, who's an R&D litigator from Morgan Lewis. With that said, we'll move on to the next slide. The agenda today is primarily going to be focused around our practice a little bit, just to give you a sense of who we are. But then I think it's going to be a really cool presentation today, because we're going to get IRS perspectives primarily around some of the new rules around R&D, potentially employee retention credit as well, and then also practitioner perspectives as well. We thought it would be interesting to have both the IRS and the outside perspective from a practitioner perspective, and then we'll open it up for Q&A to the extent we have time. So just as a matter of introduction, Tax Credits and Incentive Advisory Group at Cherry Bekaert is made up of about 50 individuals. Our focus, of course, is on identifying incentives for companies who are engaged in R&D, constructing new buildings, investing in low-income communities, investing in alternative energy, and investing in hiring as well. We focus on R&D studies, cost sake studies, employee retention credits, 179D, additionally, investment tax credits, production tax credits, anything, and also at the state and local level as well. So that's our focus as a group. And it's a national group. And I really have to also thank my partners, Ron Wainwright and Dan Mennel, for helping pull all of this together, get our speakers together, and also helping me lead many of these discussions that we're going to have today. So if we move on for a moment, this is just a little look at our team, where we're all located nationally. We have offices in the DC area, Florida, through the Carolinas, Nashville, Atlanta, Los Angeles. It's essentially growing to be a much more national firm and focused cohesively together from a national perspective, working with all our clients, both those for whom we do compliance work and audit work, but also taking on new clients as much as possible. So with that, I'm going to turn it over to the IRS to give some of their thoughts today on where we are. So take it away, Paul and Cheryl.
Thank you. Thank you, Marty. Hi, this is Paul Curtis. Hope you can hear me clearly. Good morning and happy Wednesday, everyone. Thanks so much for the opportunity to spend a little time today to discuss some of our frequently addressed areas. We'll spend most of our time, quite frankly, on the R&D credit, but we'll also touch on the employee retention credits. Just really quickly, in terms of my background, I am in small business division. I've been here nearly a full 8 months now. Prior to that, I was in the LBNI division for its entire existence. So that's just a little bit about my background. So on this first slide, Cheryl and I are going to do a little tag team on this slide. I'll get things started with a little background on where the agency is with respect to the R&D credit, and then we'll talk about some division-specific items in terms of our efforts. Just to level set a bit, I have been here in the IRS nearly 38 years, and I have been involved in the research credit a lot during that career. I think the credit came into existence in the early 80s when I was in college. So I've been involved as a specialist helping work the issue in the field as a technician. I've also been involved with the issue during my career as a frontline manager, a senior manager, and throughout my career as an executive as well. From my perspective, perhaps one absolute truth is this, that I think the IRS as an agency, our taxpayers and practitioners can absolutely align on. And in terms of the R&E issue, the issue is an extremely resource intensive issue for us as an agency, our taxpayers, and certainly our practitioners as well. To that end, from an IRS perspective, we've been working quite some time to make an effort to sharpen our focus on what we're asking both our taxpayers and our employees working the issues in the field to do. I like to think of it from an IRS perspective as a bit of a back to basics approach. As an agency, whether we are working the issue on originally filed return or perhaps even examining a claim filed, we want to align our efforts with the requirements of eligibility within the statute. That's kind of the bottom line for us. And we certainly want our folks in the field to understand the statute, whether examining a claim for refund or examining an originally filed return. To that end, we certainly would expect taxpayers and practitioners to be able to demonstrate the four-part test as contained in the statute. Now, I don't think time permits us to really get knee deep in the technical weeds, but I'm sure the audience is fairly well aware of these requirements. But in general, we do expect taxpayers to identify the qualified business component that is either new or being improved. We expect the research expenditures must be in a technological nature. The research activities must be undertaken for the purpose of eliminating some uncertainty. And the statute, of course, requires that a process of experimentation be entered into to eliminate the uncertainty. Just one other thing, Cheryl and I have participated in a lot of external outreach, and we could consider that an extremely important and valuable component of our efforts in this space. So both divisions have worked on various and sundry things in terms of initiatives, and I was going to hand it off to you, Cheryl, now to touch on some of the LB&I initiatives.
Hey, thanks, Paul. And I just would like to share a little bit of background as well. So again, I'm Cheryl Teifer. I'm the Director of Field Operations for our engineering program, which is a national program. And to the extent that Paul and I can deliver, our messages together is a great opportunity to our external stakeholders. As Paul has responsibility for the field functions, I have responsibility for the specialty areas, and to the extent that the engineers within IRS do support, especially in the research credit area, making some of those technical determinations on what does provide for qualified research activities. I will say, and I think Paul said earlier, obviously the issue for research credit is very resource intensive, both for the service and for our external stakeholders. But just to kind of level set a little, the engineering program currently houses roughly a little under 150 engineers. Now, Paul's organization probably carries about 3,000 plus revenue agents that we would support, but our program not only supports Paul's organization, but the entire IRS. organizations. So to the extent that we support TEGE and estate and gift and LB&I and as well as small business. We do sit in LB&I, but to the extent our responsibilities are much broader. I think Paul did touch a little bit. The service is really focusing on the requirements under the statute for IRC 41 and establishing that we do have upfront qualified research activities. And to the extent that we can align them with a business component, we are truly focusing on establishing that criteria upfront. And as Paul said, we've done several stakeholder feedback sessions at which we get quite a bit of feedback from our external stakeholders. And a lot of it is really asking the service to clarify what are the expectations? What is it that you really need for the support for the R&E issue, just in general? So you'll see that a lot of the initiatives that Paul and I are involved in are really focused on how do we provide that clarification? And then to the extent that we have limited resources, how do we deploy those most effectively and efficiently in reviewing the compliance aspects of the research credit issue? So as Paul said, there are a few initiatives that are out there that we've been focusing on, and many of them are aligned to better risk assessing information that we have on the research credit. So we have established a team that includes a small group of highly skilled and subject matter experts in the area of research credit to assist our field functions in determining if the issue presented on a return by a company presents risks to the service that we should deploy resources. And when I say a team, it includes subject matter experts from our enterprise function, our field function, as well as managers, technicians, and counsel. So we feel like we have a pretty good group to kind of help us assist in identifying where do we actually deploy these resources. And that gets us into a directive that was issued by our commissioner around centralized risking, again, focusing on where do we deploy these resources. And to the extent that we have a CAP program, we have also established a questionnaire where CAP taxpayers actually provide us some detailed information that better assists us in risking their potential research issues and research credit. And to the extent that through that process, we truly look at less than 10% of our CAP taxpayers for this particular issue, just because we have that additional information to better assist us in risking. We do have a research issue campaign from which the goal there is to learn more about the issue. Where do we need more guidance, not only for the service, but for external stakeholders? Where do we see the highest risk issues? Is it in our internal use software area? Is it in our pilot model? So we can better align ourselves with where we need to focus. Again, our very limited resources. And then the last piece is we continue to look at industry issue resolution opportunities. So if there is a particular industry with an issue that we can focus on, we try to do that. As a result of one of our industry issue resolutions in the high tech area, we started looking at the ASC 730 directive and how do we update that? Again, in an effort to really deselect a portion of the credit that does not present us the highest risk to deploy resources. So to the extent that ASC 730 costs can be identified, we can deselect that portion. And then I know Paul started on a little bit of our most recent initiative, which we have truly been working on for almost 2 years. And that is, how do we obtain better information on research credit claims? And Paul, I want you to also touch on, some of the things that are going on in SB as far as your centralized efforts.
Yeah, so thank you, Cheryl. Just to level set, in the past, SBSE deployed technical resources to the R&E issue on a bit of a nationwide basis within the 7 different exam areas of small business to address the research credit issue. And so to that end, our technicians were spread around the country with a variety of experience levels in the issue for both our managers and the senior managers and the numerous area directors such as myself. And so a couple of years ago, in SBSE, the decision was made to consolidate all the folks working R&D credit issues in one nationally based territory. They're still spread throughout the nation, but all these technicians working the R&D credit issue are now in my executive footprint. And from our perspective, consolidating both the leadership and the technical resources under one common umbrella, it's been extremely helpful to leverage common leadership and to grow the technical expertise within the division. And I would note that in SBSE, a large majority of our compliance efforts are in the claims arena. In January, the IRS communicated our requirements for the R&D credit claims, which is in alignment with the Treasury regulations with respect to claims. This strategy is intended to increase both the efficiency and the effectiveness of the agency in the claims piece of the R&D credit. The intent of the process is to provide a greater understanding by the agency in understanding the reason and rationale for a taxpayer's claim for the R&D credit. As noted earlier, as Cheryl noted particularly, our technical resources in both LB&I and SBSE are stretched very thin. So the intent here is to afford the agency the ability to discern why the claim is being filed and eliminate the need for the agency to devote any technical resources to work on claims that can be allowed without an exam touch. The intention here is to create a process which will allow us to deselect claims and only deploy our technical resources to claims having the highest compliance risk. As noted, the intent is to secure the information needed to reduce our examination of claims in this space. Cheryl, I don't know if you have anything to add here. If not, I think you will have the polling question coming up next. I don't know if you want to add anything to that.
No, Paul, I think that really covers kind of the efforts that we're doing in the claims area. I can say that we have been recently receiving claims for which taxpayers have been successful in meeting the requested information. So really in compliance with determining that that they have filed a valid claim. And the only other point I would make is really the claim strategy is the focus is to determine if a valid claim has been filed and that the company or the taxpayer has met the requirements under the Treasury reg that request that there be sufficient information to apprise the commissioner of the purpose of the claim. So I think that that is really a big goal for us. So as you said, there's a polling question. So how often do you review your R&D credit support to confirm it is IRS ready based on the most recent guidelines? I think you all hopefully have an opportunity to respond. Okay, there we go. So it looks like 41% of you annually review, 2% every other year, 17% unsure, and 40% not applicable, or I guess we don't care. So, so let's just touch quickly on the next slide. So when we talked about the claims for strategy, there were a number of activities that the service took on, and that was to provide a press release in October that kind of shared the interim guidance and the guidance that the service had received from Chief Counsel on what we could expect or should expect in filing a valid claim. The second thing we did put into place was a transition period. We've got a 1-year window. The claim strategy was effective for January 10th. We put a 1-year transition period in for not only taxpayers and companies, but also the service to implement this new expectation. Along with that 1-year transition, there's a 45-day period to cure any defects within the claim. So taxpayers will be notified if their claim does not meet the criteria and will be given 45 days to perfect it. And we will be sharing with taxpayers where the deficiencies are. The third thing is we continue to dedicate a box for taxpayers, external stakeholder, and feedback for comments. Again, we're looking to not only make the transition for a year on how this is working, but also learn from what we're doing and is there a need to make modifications. And then lastly, we continue to identify FAQs that we need to provide additional feedback and publish those as well. So to the extent that there are further questions as we learn, or as taxpayers and companies learn how they meet this expectation, we will be focusing on additional FAQs. And I think we'll move on to, so then we have, so I would say that pretty much covers many of the initiatives that we have ongoing with the service. Other than for research credit, we are also looking at potential form changes under the Form 6765 to the extent that if we can obtain more information up front on that particular issue, again, we can better risk assess and determine if additional resources for compliance efforts need to be deployed. So that would be another item that we are looking at this time. So the last piece of the presentation really was just to kind of touch on the employee retention credit, which was brought, has been available in the past, but most recently under the CARES Act, it was a new credit that came in to allow employers to get a benefit for maintaining and retaining employees on their payroll during COVID and other events similar to that. So, this credit is still available. It's reportable on the 3800. There's a notice of, I think it's 4147 that provides additional information on the credit requirements, as well as individuals and contact information for further assistance. And Paul, I don't know if you have anything else that you wanted to share in this area?
Yeah, just one thing, a question that's come up recently, and I haven't thought about it a whole lot, but the question came up with respect to IRC section 280E, whether this applies to this credit. And for those of you who don't memorize the Internal Revenue Code, that section pertains to a company's ability to take tax deductions and credits in certain industries. For example, the marijuana industry, that's a great example where it's still listed as a controlled substance for federal purposes, despite the legality in particular states. I don't think any guidance has been put out to that end, but I'm certainly working with the policy folks to try to there's some frequently asked questions on irs.gov, and that's something I'm trying to actively pursue now to get some clarification, because normally folks in those type industries have very limited ability to take deductions or credits. And so that's what I'm trying to get some clarity on. That's an outstanding question, but more to come there.
Hey, Paul, thanks. So I just want to clarify. So it is a notice 1447 that would provide additional information on this particular credit, and more specifically as it pertains to the CARES Act and what's available to companies under those provisions. And I guess I'm going to turn to you, Paul, for the next polling question.
I get polling question number 2. So the question is, has your R&D credit ever been audited by the IRS or perhaps a state? Your choices are yes, no, what is the IRS? That's my favorite answer. And certainly not applicable. We don't take a credit. So interested to see that coming in. I have a guess on the percentages, but I'm not gonna, I'll tell you if I was right or not.
We'll see how lucky you are.
I'm not very good when I go to Vegas and guessing, so.
Yeah, and
Well, I was going to say yes at 20%, so what wasn't too far off. And I thank you for the 2% who actually gave me a laugh today. And so really, really interesting. Thank you for allowing us some time today. We're great to be here.
Yeah. Hey, Martin. Thank you, Martin, Dan, and the Cherry Bekaert team for the opportunity to present this morning and putting together such a good program. It's always a pleasure and a privilege to be amongst R&D professionals who are living in this space, which is, as Paul and Cheryl alluded to, it's a hard space, and it's good to share knowledge. Cheryl and Paul, thank you very much for sharing your time and your perspectives at this event, and also just more generally at other stakeholder events. It's very welcome and appreciated, and I think it's productive and healthy for the system. So thank you very much. I enjoy hearing it. Next slide. Just a little bit about myself. So started working with the research credit in 2004, maybe not as long ago as Paul, but for a while. Plenty of scars, and it's become a focus of my practice. You know, you can't do tax controversy and avoid research credit disputes and transfer pricing disputes, basically. A couple, quick plugs, but they'll be quick, is a colleague and I have published a treatise. I'm holding it up, called Legal Guide to the Research Credit. It's currently in its 8th edition. There's no strokes of genius in it, but it is a comprehensive compilation of the relevant authorities, from regulations to the statute, obviously, the legislative history, the cases, and IRS guidance. And it collects that, reviews it, and distills it. And I like to think of it as one-stop shopping. And I hope it is a helpful resource for people in this space. And I will note this coming November will be Morgan Lewis's 8th annual R&D Tax Credit Symposium. It's an event that has gotten a lot of traction. Last year, we had about 600 attendees representing 100 companies and about 80 providers. And we have thought leaders who share their insights and knowledge, both on kind of recent developments, sorts of things that Cheryl and Paul just touched on, and also kind of the thornier type issues that really kind of are a little bit difficult. So if you, no strings attached, if you want to be invited to that and you're not on the list, just email me and I'll put you on the list. Research credit, as everyone knows, is widely claimed by over 15,000 companies, and it comes in all shapes and sizes. So this slide shows the industries that my matters have involved over the past 10 to 15 years. And, it keeps the job very interesting. R&D is done in many different ways, and so constantly learning about R&D activities. We try to, if at all possible, to resolve cases at the earliest opportunity, whether that be appeals or, better yet, even an exam. But there's a process that goes from beginning to end, and sometimes taxpayers have to litigate. These are the research credit cases that I've been involved with over the years. I will say, they're concentrated around historically contentious issues. I'd say one is substantiation. Where is the bar? Where is the line? How good is good enough? And that's a recurring issue that I think both the government and taxpayers have struggled with. Another is production costs used in research and the creditability of those typically supplies, but that's a recurring issue, still seeing it. And then the funded research exclusion. So those are, issues that tend to make their way to litigation for whatever reason. And I guess that's representative of my experience. We can go to the next slide. I'm going to talk about recent developments that, I pay attention to and collect for the book, and just to be able to advise my clients. But Little Sandy is, it's not really new. It came out last February, but I would say it's probably the most significant case that's been decided in recent years, probably since Souter in 2014. And I'm going to spend 3 minutes trying to distill a 60-page opinion, but basically Little Sandy involved developing a barge in a dry dock. The facts are very similar to another case decided about 10 years ago by the district court in Texas, that found that 2 prototype first-in-class ships built for sale involved qualified research and were eligible for the credit. And in Little Sandy, the QREs at issue were largely production costs. They were the cost of building the ships, both supplies and the wages paid to production workers. And Little Sandy's position was basically based on Trinity, as These ships were novel and complex. More than 80% of the components were novel and complex. And so we passed the substantially all tests. More than 80% of the activities involved a process of experimentation. And so, like Trinity, we should get the credit for the cost of developing and building these ships. And then alternatively, Little Sandy argued that even if you consider looking at the activities rather than the novelness of the ship, that 80% or more of the activities were direct support performed by the people building the ships, and that those were includable in the substantially all fraction, and thus even under that formulation of the test, they pass it. So we can go to the next slide. The tax court and basically pumped the brakes and disagreed. The tax court disagreed with Trinity's analysis. And Trinity, the district court, looked to the novelness of the ships and said if 80% or more of the components were new or novel or innovative, then the process of experimentation test was passed. The tax court rejected that analysis and said you really have to look to the regulation, and that requires a mathematical analysis where you look to the activities, and 80% of the taxpayers' activities have to constitute elements of a process of experimentation. And then rejected Little Sandy's argument that the direct support services were includable in the fraction and pushed them over the 80% services, 80% fraction. And the tax court said direct support is different than engaging in experimentation, so you don't include the direct support activities. And you know, I don't have I don't take issue with that ruling. I think the substantially all fraction really does look to the direct research and direct support. Little Sandy decided to argue that the production worker activities were direct support and not direct research. And I question whether that's actually the right result when you're developing a prototype, building the prototype. Perhaps in that case, that the activities of the people building the thing to be evaluated should be part of the direct research being done, but Little Sandy didn't argue that. Next, the tax court said that the tax court said that those direct support activities should not be included in the denominator. And then if you just look to the engineering time and the management time, Little Sandy had not shown that 80% or more of those activities were part of the process of experimentation. So we can go to the next slide in the polling question. Polling question 3 is, do you take any pilot model costs as part of your R&D claim? All right. So yes, no, pilot what, not applicable. So collect the results. 15% yes, 24% no, pilot what, not applicable, 52%. I mean, the pilot model concept was embraced in regulations that came out in 2014 as R&D expenditures and by extension QREs. And there's a lot of push and pull going on in the system right now as to what is a pilot model and what costs come in under that concept. So that's like many of the issues going to take some time to play out. And Little Sandy, the big picture, I mean, it's hard to get into the grist of it, but basically it comes down to the prototype cost, developing a prototype. The district court issued a taxpayer favorable decision. The tax court pulled back and went a different road. I will say Little Sandy is currently on appeal to the Seventh Circuit Court of Appeals, which governs states in the Midwest, and we'll probably get an opinion from the Seventh Circuit, which is one of the highest courts and the highest of these three courts, probably later this year or early next year. So time will tell. Next slide. Other recent developments. The first, Cheryl alluded to this, and this is kind of through the grapevine from my perspective. I've heard that changes to the Form 6675, where you itemize your QREs, are under consideration and more information may be required. So we're paying close attention to that. And I've also heard, although it didn't come up today, that perhaps changes to the statistical sampling methodologies in the context of research credit claims are under consideration. There is a revenue procedure governing the use of stacked sampling. It can be used to determine and defend your credit, but apparently that's being looked at as well. You know, the next bullet is Section 174. The world changed this year. Since 1954, taxpayers could elect to deduct their R&D expenses, and Congress back in 2017 changed that prospectively starting this year. And now those costs have to be capitalized and amortized and recovered ratably over 5 years for domestic research or 15 years for foreign research. And so, I mean, that's a sea change in the treatment of R&D expenditures. And costs that taxpayers have historically treated as 174 costs or Section 41 costs, you know, those are very likely going to have to be now capitalized and recovered over a longer period. And taxpayers need to be taking a look at their costs more generally as to what other types of costs might fall in within the definition of 174, which is quite broad. I would say there's still a possibility of a legislative fix, has bipartisan support, but it's expensive. It benefits companies and not individual taxpayers. So it's not a sure thing. I'm not a lobbyist. I hear that there's still reasonably possible, but who knows? Cheryl touched on the directive. My observation is that, you know, there has been some pulling back on the scope of the directive. For example, in the software development space, you know, it's been limited to development activities to create externally marketed software as opposed to software used in providing services to outside parties. And you know, costs under intercompany agreements, even though those don't raise funded research considerations, that those have to be deducted from the AS 730 costs. And, you know, this is an administrative solution. It's the IRS's solution. And so if they interpret it a certain way, it is difficult as a practical matter to, you know, other than get an audience and make your case, to have much other recourse, unfortunately. Software development claims I continue to see as being a source of controversy, both on hosted IT costs being claimed as leased computer expenses, and more qualitatively, you know, the substantiation and qualification of the development activities themselves. And go to the next slide. You know, the most pressing compliance issue, I think, for taxpayers right now, and this is, you know, Cheryl and Paul discussed this at some length, is the focus on business components and proof of claims at the business component level. And in my mind, this kind of raises the question of, you know, what happens when an immovable object hits an unstoppable force hits an immovable object, because it's two competing considerations that are just really difficult to reconcile. And I observe that most taxpayers have cost accounting systems that are, you know, SAP-based, Oracle-based, and they collect costs at the department level and not at a project level. And so it's really difficult. The systems just don't collect information about activities or costs at the project or business component level. And, you know, the service, for good reasons that Cheryl and Paul alluded to, you know, feels that they need to focus on business components and demand proof at that level to kind of vet the claims and, you know, deselect the good ones and focus on the bad ones. And it's just it creates something of a quandary given these two competing priorities. And I don't have any silver bullets or quick kills on this issue. I think it's going to take some time to play out. My hope is that reasonable minds on both sides can kind of find a middle place that satisfies both of these priorities, but we will see. You know, this is the FAA. Probably everybody who works in this space is familiar with it, so I'm not going to say it, but it basically requires a refund claim to identify exhaustively all business components and then describe the research with some detail for each of those business components. For some taxpayers, this might be very doable, but some taxpayers, you know, during a year, they work on hundreds, thousands. I mean, you think of Bear was one of the cases I alluded to earlier, you know, thousands, tens of thousands, and this is going to be really difficult to comply with. Now, this is limited to refund claims specifically, but if you go to the next slide, I guess what I'm seeing in my audits is that IDRs and audits of research credit claims made on original returns, so they're outside the scope of the FAA, are basically, you know, cut from whole cloth and restating the same request as are in the FAA. So it seems to have expanded, and it really is being demanded for all research credit claims, whether on amended returns or original returns. We go to the next slide. I think it's fair to note what the legal basis that I've seen. Now, I'm not the service, and I don't. This is just my observations. But what I've seen, the kernel or the nugget is a statutory provision. Comes right after the four-part test, Section 41D2. Four-part test is in D1, and this is D2 Cap A. And the statute says paragraph 1, which is the four-part test, shall be applied separately with respect to each business component of the taxpayer. So you have to take the four-part test, and you don't employ it at the level of a taxpayer or an individual employee. You apply it at the level of the business component. And that is being construed as legal authority for imposing a substantiation requirement. And that's the basis, or that's one of the bases. That's the one I see most frequently. So that's kind of one side of the coin. And I think it's fair just to recognize that the reality is this, and it's been acknowledged for now 20 years, as it's very difficult to do this, to collect and present proof at a business component level, because the reality is companies, their cost accounting systems that they use for non-tax purposes to budget and create financial statements and things like that, they don't keep this information at business component level. And so it's not to say it's impossible in all cases, but it's really hard and really difficult. And that's been kind of an acknowledged fact. And that was the case 20 years ago when this statement was made. It's still the case today. It's always going to be the case. I think the priorities for, I think the government has seen a lot of refund claims, and this is an administrative way to work through that. And I'm not the service. I think that's a valid tax administration purpose, but it creates a real difficulty for a lot of taxpayers. So what do you do? I know this is, again, no one size fits all sort of thing, but when I discuss this with affected companies, that's it. Some clients, some companies, engineering firms, government contracting firms, that they make their revenue based on performing projects. So they use project accounting, and they do track costs and activities at a project level. If you're in that minority, I think that's like 10 to 15%. Most manufacturing concerns aren't going to fall within that bucket. But if you're in there, then the information's still going to be a project, but it's doable. The information's there. I think the harder question is, what do you do if you use departmental accounting, a SAP or Oracle-based type, more typical accounting system where you don't collect costs on business component level. And one approach is just kind of adopt a project tracking system specifically for research credit purposes, and where your people who are doing the research, they clock in and they track their times, and it provides the information needed. So that's one approach. Another is to use stat sampling. I mean, that's an accepted way to take a large population of items, whether it be employees or whether it be business components, and to slice it down and then use the power of science to analyze the eligibility of that small sample and extrapolate it back to the universe. I think given the current environment, that has to be considered more seriously by a lot of taxpayers as a way to streamline and solve this problem. And the third is just, hate to say stand your ground, push back, but there is a case to be made that if you use departmental accounting systems, that you should be allowed to leverage those systems. You still have the burden of proof. You still have to prove your case, but legally you could push back at the notion that you have to identify everything for however many hundreds or thousands of business components that you work on during the year, and make the case. We've done a thorough study. We do qualified research. We've studied it. We've leveraged our accounting systems, and we've met our duty of substantiation. So those are the options on the table. Polling, as I see them. Polling question number 4, are you comfortable that the way you gather support for time and activity meets the IRS requirements? Yes, no, maybe. Not applicable. We don't take a credit. All right. Looks like most people, well, a large minority, 47%, 48%, about half are comfortable. 7% no, small percent, very small percent maybe, and not applicable. Again, we have the people not taking the credit. All right, just a couple more slides and I'll be wrapping up this whirlwind. You know, I alluded to one option on the table is to stand your ground and push back. You know, I could construct an elaborate legal argument as to why substantiation is not required at a business component level, and it would look to statements that, you know, this is hard, taxpayer systems aren't set up, taxpayers should not be required to adopt new systems specifically for the research credit. There's statements that taxpayers should be given reasonable flexibility in the manner in which they substantiate the credits. I think if you look at the legislative history, you could recast the statutory provision that we looked at as more imposing an analytical framework for how you apply the 4-part test as opposed to imposing a substantiation requirement. And then there's a case Souter, which adopted proof of QREs based on kind of an annualized allocation that didn't tie to specific business components. I mean, it's a case, it's based on its own facts, but that's supportive. And, you know, you can weave together basically an argument that, I mean, just to be blunt about it, kind of lowers the bar. And then you have to build up your facts as to how you exceed the bar. But, you know, my own view of the world, and for what it's worth, which is not that much, you know, I don't administer the laws, I just try to help navigate them, is that, you know, you do your best with the systems you have to prove the case and meet your burden of proof. And it has to be a reasonable, good faith undertaking. I mean, this is taking money from the federal government and the fisc and other taxpayers. So it's not as if you can just claim the credit. You have to do a thorough job. But for purposes of claiming the return, and I think if you want to test those QREs on audit or in litigation at a business component level, that you need to do that through statistical sampling in most cases, and that provides a scientifically backed way to check those QREs and make sure they're not good and to adjust them as necessary. So that's kind of the broad outlines of the other point of view. Parting thoughts, you know, this is on best practices based on experience, and it's a little bit stream of consciousness. But I will say, you know, as I've already alluded to, you got to consider stat sampling right now, given the focus on business components. I think it's a way to cut through this. Just a personal preference when you're presenting your research and studies or in responses to IDRs, it's just kind of stick to the facts. I see a lot of adjectives and adverbs that I think turn off the reader as opposed to making your case. Avoiding binder dumps and similar techniques. Examiners are people too, and they don't like having stuff dumped on them and heavy-handed tactics. So I think you need to engage and work with them and provide the information in a usable way. Go into your audit ready and not flat-footed. You know, the expectations from LB&I and the service is that the parties will, you know, work through these together and collaborate and communicate and not play games. And I think both sides have obligations on that side. So I think it works best when people try to do that. Generally try to be responsive and cooperative. I mean, the government has a right to this information to evaluate the liability. That's just kind of basic law. There are times when you have to draw lines. I mean, there are, and but you want to be selective and thoughtful, and be sure you are on solid ground. You know, we're dealing with R&D, we're dealing with trade secrets, proprietary information, and companies want to protect that. They don't want it falling into the wrong hands. And on the other hand, you know, the service is governed by a statute 6103, which basically requires them to keep taxpayer information confidential. So I've seen this kind of become a side issue that can kind of take an audit off track. And I think there's got to be a reasonable approach somewhere in the middle that balances those concerns. So talk through that. And, I'll start where we finished. This is a fact-intensive, difficult area that can spiral and become protracted and expensive, which is great for the lawyers, but it's not great for the taxpayer or the government, which has limited resources. So I would hope that parties would strive to find common ground. There's usually a place in the middle, and try to do that as early as possible, if possible. Sometimes it's not, and that's just the way it is. So, okay, well, again, I really appreciate the opportunity to speak with you today, share some thoughts, and welcome your questions, and look forward to meeting people in the future. Thank you.
Alex, thank you very much. And I'll just maybe add one comment at the end here. This is Marty Kerman. As the service provider standing between unstoppable forces and immovable objects, all your points certainly make a lot of sense to me, both on both sides of this, from the IRS as well as from you. I think our goal at Cherry Bekaert is always to take the data that's available from a client and use some of our own tools to enhance what we can and aggregate data according to business components, both to make it easy for the IRS and to make it easy for the IRS to understand. It's also helped the taxpayer understand exactly what the qualified projects were. And so all of these comments today were great. And I just want to thank everybody. So we have a fifth polling question, and it's very simple. What is your primary purpose for attending today's webinar? And we'll see what comes up. And then additionally, I'll add some concluding thoughts and after the results come through. Okay, interesting topic, 35%. Knowledgeable preventers, 13%, CPE credits, 47%. I'm sure CPE is very helpful. And then required for the job. Excellent. Well, with that said, this concludes our session. Thanks so much for joining us. If you have any additional questions regarding today's topic, please reach out to me anytime. We totally value your feedback, and we ask that you take part in a short survey, which is now going to be posted in the chat. Our next webinar, beginning in about 20 minutes, legislative updates impacting C&I, updating credits and incentives. I hope to see you there. It's going to be another really good one. And thank you so much, everybody, for attending. And really thank you again to my partners and to our panelists today. Everybody did an amazing job, and we couldn't appreciate it more. Thank you.